Thank you very much. Thank you for the introduction. Good morning, everybody. I hope that you are all enjoying your stay in Dubrovnik. I am. And this is going to be the subject of my presentation, executing reinsurance or insurance in the London market, a Croatian law perspective. And then the question is, have digital platforms, e-documents and e-signatures changed the old ways or the old rules? If they have, how they have done that. That's the question we asked at the beginning. It may sound strange, how can there even be a Croatian law perspective about placing insurance or insurance on the London market? Well, there is, because it's quite a long tradition and quite a frequent business practice in Croatian shipping, that ships and yachts and boats, yachts really, are frequently insured on the international markets, reinsured on the international markets, but they still are covered, partly the risks are covered by Croatian registered insurance companies, or they have local brokers that mandate basically the risks through EU registered brokers and over to Lloyd's registered brokers to place the rest of the risk, and this is usually the majority of the risk, on the international market. And mostly this is done really in Croatia, traditionally has been done on the London market. And although the majority of the risk is covered by London underwriters, the contract of insurance is subject to Croatian law and exclusive jurisdiction of Croatian courts, because there is such a stipulation in the contract itself. So it's a choice of the parties, and it's quite a frequent business practice. This presentation has been inspired by a real case. There was a Croatian ship owner, even the flag was Croatian. There were two ships in question. So they had a local insurance broker in Croatia who then engaged an EU registered broker registered in an EU country outside Croatia. This broker then placed the risks on the international, mostly EU market, and then these risks were reinsured through a Lloyd's registered broker on the London reinsurance market. They stipulated the Croatian law as governing law and the Croatian jurisdiction of Croatian courts, and the mortgagees, who were foreign financial institutions, questioned the validity of those insurance contracts because of this application of Croatian law and Croatian jurisdiction. So they were worried about that stipulation. And they were also worried, it seems, that they were not very familiar with the practice of placing risks on the London market, how it is technically done. So they were very confused with the documentation, the insurance documentation that was issued to them. So they asked for a legal opinion. And this is how the analysis started. So the questions were several. First of all, can an insurance intermediary registered in an EU country or in the UK issue valid insurance documents under Croatian law? And what kind of those insurance documents would they be? So they were expecting to see insurance policy. And obviously, these were not insurance policies. These were different insurance documents. We will discuss that a bit later. And also, their question was, what is the legal and regulatory basis for such procedure under Croatian law, and in what capacity does the insurance intermediary issuing these documents act according to Croatian law? Because they were confused, how can a broker who is actually acting on behalf of the insured issue a valid insurance policy or a document? So those were their questions. Now, I'm sure that most of you in the room think that those questions are really strange, but this situation really happened. And what kind of documentation did the insured possess? Well, they had several documents for each of the ships, and they all looked pretty much the same or similar. So this is like the front cover of the document, showing the policy number, the name of the insured, and it says that it's a certified true MRC. It stands for Maritime Reform Contract Copy Document, and it has a handwritten signature on it. And this is handwritten signature of a Lloyd's accredited broker. And then the document looks like that. It's a standard form because Maritime Reform Contract has been a standard on the London market for many years now, since 2007. So all these MRCs look pretty much the same. They will state the policy number, the unique market reference number, risk details. There will be, so this is a marine hull policy, basically all essential elements of the insurance contract, the conditions that are contracted, and there is that stipulation of choice of law and jurisdiction. And here I also extracted the clause explaining how the execution of the contract, the mode of execution of the contract works. And there are several ways the clause says that the contract can be concluded. And then in the end, we have security details. So these are, it used to be in the past, before the electronic documents, it used to be handwritten signatures, like this one, for example, and also the share. This is the signature, obviously, of the underwriter and the share of the risk written. However, these documents, some of them had these kind of signed underwriters sections. So there is no handwritten signature. These are not even electronic signatures. These are details about so identifying the underwriters on the London market, their share written, and it says here, I covered blue because I can't show that, but it just says the name, it's a typed name of a person, physical person who signs the document and the time and date of signature, but that is not technically an electronic signature. But it is a trace that shows that this document has been signed by the underwriters. So some MRCs that were issued had this kind of signature. When you make it bigger, it looks like that. And then some of them had this kind of signature. And altogether, when you put them all up, it gives 100% of the order, it's covered. So the whole order of the client is covered, the full risk is underwritten on the London market, but you have to put all those documents together and interpret it. So, the client was very confused. And this came from a broker who is actually acting on behalf of the insured. And now, what is the legal framework that we have to apply? We have we are an EU member country, so we have to apply European directives, insurance directives, and the two most important ones are the Solvency II directive and the Insurance Distribution Directive. And they are all transposed into our Croatian Insurance Act. So for those of you who are familiar with European insurance law, basically Croatian law is really well harmonized with the European insurance law. Then we have insurance contract law, which is purely national, and it is regulated in when marine insurance is in question. Then we are looking at the Maritime Code, Croatian Maritime Code, that contains provisions on marine insurance contracts. And as a lex generalis, we have the General Obligations Act, but only in the part where it regulates, where it contains general provisions on contracts and obligations. So that's the contract law framework. And finally, we had to look at the regulation of electronic commerce. Again, European law, really, that is then implemented and applied in Croatia accordingly. So Electronic Commerce Act and the EIDAS regulation. Now, in that legal framework, if we look at the status of the insurance intermediary, we can conclude that in this case, we had insurance of large risk. This is terminology from EU directives. And the risks are, according to this regime, located in Croatia because the ships had a Croatian flag. And we had two foreign intermediaries. One was an EU authorized broker in another EU country, passporting to Croatia, and the other was a UK-based Lloyd's accredited broker. And well, we're now looking at, so this Lloyd's accredited broker is outside this jurisdiction, so we are only had to see how the EU authorized broker fell into the picture, and it comes out that this person is acting on behalf of the insured. In Croatia, we don't have a possibility of dual agency, so one person, one intermediary can only represent either an insured or can be an agent for the insurers. So it cannot do both. It's either or. So in this case, although this EU broker was registered in another country in Europe, and it was licensed to represent on both sides, in this case, it worked only on behalf of the insured, which was in accordance with the Croatian legislation and the EU legislation. So it was notified to Croatian supervisory agency to be passporting business in Croatia. So it was working on the principle of freedom of service, cross-border freedom of service within the single EU market. So then, now we have to look at how just to bring you into the story, go through the method the risks are technically placed on the London market. I'm sure that most of you in the room know. I would just like to go through that to basically compare those documents that I showed you in the beginning with this old-fashioned and still working method of placing risk on the London market. So how in reality it works? Basically, in this Croatian case, an EU authorized insurance broker that passports its services to Croatia, they effect insurance with Lloyd's Europe and other European authorized insurers. And then after that, Lloyd's accredited London brokers effect reinsurance of those risks on the London market. And in this case, it was also interesting that the EU authorized broker was a subsidiary and it was fully owned by this UK Lloyd's accredited broker. So this is actually a consequence of Brexit. Before Brexit, we didn't have to go all these steps. We could go straight on the London market. And then now the general rule in the UK law and also in Croatian law is that a marine insurance contract is deemed to be concluded when the proposal of the insured is accepted by the insurer. So it's a consensual contract. No special written form is required. However, parties can agree otherwise, and they can agree to have a written form as mandatory. In the Lloyd's market, these individual insurance contracts are usually are normally and always concluded through the so-called slip placing system. And how it works is that the accredited Lloyd's broker creates the slip. This is a written document containing basically all the relevant details, contents of the insurance contract. Then it is submitted to the underwriters for their quotations or firm orders. Oh, sorry, not firm quotations or indications. And then when the quotation is given, it is presented to the insured. And if the insured is happy with the quotation, it then gives the order to place the risks on the market through its broker, and this is considered a firm order. Then and then it's when it's signed by the underwriter, the contract has been executed. So by signing the slip, the underwriter confirms his consent to participate on the risk. So we don't have signatures of insured, but we do have a signature of the underwriter signing to the risk. So along with the signature, we saw normally the percentage of the risks is also stated on the slip. And then the process is repeated until the slip is completely filled, until 100% of the client's order is covered. And this negotiation process and the underwriting and signing process is performed nowadays in various ways, sometimes face-to-face, sometimes electronically, by phone or otherwise, but more and more it is done electronically. And also the market has introduced digital platforms that are used for these electronic communications, and for all these basically steps are done electronically through these platforms. However, not all underwriters use that electronic platform. So sometimes some of them still have put their handwritten signature on the slip, and some of them put the electronic signature through the platform. So in our case, what were those documents that we showed in the beginning of the presentation? Basically, the EU authorized insurance broker was established by an accredited Lloyd's broker, and this EU authorized broker provides certain insurance documents to the insured in a form of, these were all in PDF, and they were printed on the broker's letterhead. So trying to answer the question, what is their legal nature? Well, according to the common business practice followed on the London market, those are slips. Those are broker slips, right? and some of them were signed by hand, some of them were signed electronically. This is why we have all those different last pages that we have seen. However, those documents were PDF documents, and they were not original slips. They were certified copies. The original slips were held on file by the broker, and the broker issued only certified copies. Now, at the same time, the broker holds paper documents as MRC certified copies, but also in the database, in the platform, it keeps electronic version of the MRC. And so it has two systems in parallel, one in paper and one in the digital platform. And what the PDF documents that came out and were issued to the insured were actually just a trace of what there is in the database. So they were just an evidence. They were not physically the original slips. And how does that then fall into our Croatian law framework? Is that valid? Well, it is, for simple reason that under Croatian law, there is no written form for marine insurance contract prescribed. So it's a consensual contract. The contract is executed once the parties have agreed on the essential elements of the contract. And the only document that is mentioned and that is regulated under the Maritime Code is a marine insurance policy. And the code says that this policy only has to be issued upon a request. So there is no duty, no obligation to issue a policy. It only has to be issued when it is requested by the insured. And when it is issued, it has to be duly signed. And even when it is issued, it does not represent the contract itself. It's a written evidence of the marine insurance contract. Then, if we look at this as a potentially electronic document, and the marine insurance policy can be issued as an electronic document, then it has to comply with the technical requirements of the Electronic Commerce Act. So basically, the essence is that the contents and the identity of the signator has to be certain. If there is a marine policy, it has to only be signed by the insurer and not by the insured. So were these marine insurance policy questions in this case? No, they were not. They were not issued by the insurer. They were issued by the broker. And the broker, because it's a normal business practice, holds all on their files all the data relevant for the contract, for underwriting and claims, and is usually and commonly issuing different kinds of insurance documents, such as cover notes or insurance certificates, which are not insurance policies. These are just different kinds of insurance documents that are used in practice. And these documents in business practice in Croatia are well received and usual and common, and they're valid under our law. To conclude, in this case, this EU registered authorized broker was passporting insurance services to Croatia under the rules of the freedom of services from the EU directives. This broker was had the capacity to conclude marine insurance contracts for Croatian flagships on the international insurance market on behalf of the insurers. This was also in line with the IDD and Solvency II directive. The insurance documents commonly provided by these brokers in the form of PDF documents are not insurance policies. They are documents confirming that the risks have been placed on the international insurance market according to the insurance order, and they are an evidence of the content of these respective insurance contracts, as well as the proportions of the risks accepted by the participating underwriters. And this is a standard practice that insurance brokers maintain all relevant data about the risk and the contract, and also the document and all the information. And these data and documents can be held in an electronic form. So nowadays, insurance brokers, as we said, usually prepare these insurance documents based on an MRC standard when we're talking about the London market. And this is in accordance with the common practice, basically broker slip placing system. Some underwriters then sign to them electronically, some sign to them in a paper form. And these MRC documents are originally created and kept by the broker in an e-form, in most of the cases, in an e-database. And this then allows an electronic risk placing system, while the content is then printed to a PDF document or certified copy of the MRC document in a hard form, and then kept by the broker, and can be issued in that form to the insured. So basically, in this case, we concluded that the documents were would be admissible in court and would represent a strong evidence of the concluded marine insurance contracts and their contents, although they were not marine policies, but they were well recognized as valid insurance documents in practice. So thank you for your attention.